I'm Chance Storland, and this is The Docket, our weekly interview program covering law and crime in San Antonio from expressnews.com. Brought to you today by the law offices of Pat Maloney. A 9-year-old murder case is coming back to a Bexar County courtroom as a San Antonio woman convicted of soliciting the kidnapping and slaying of her ex-boyfriend in 2010 and sentenced to 70 years in prison is going to be retried. The defendant, Vanessa Cameron, is the daughter of a retired San Antonio police officer, and she was convicted in what was called a failed scheme to collect a hefty life insurance payout by orchestrating the death of her child's father via bus driver Samuel Allen Johnson Jr. However, the Texas Court of Criminal Appeals granted her a new trial, ruling that her constitutional right to a public jury trial was violated. We'll get to all those details here, Elizabeth. Why don't you tell me a little bit more about the case?
Sure, Chance. Vanessa Cameron and Samuel Allen Johnson Jr. were in a relationship and they had a child together. But something went wrong, and prosecutors alleged she was the mastermind in a plot with 3 other people to kill him and split a $750,000 life insurance policy. So a week after the slaying, Vanessa Cameron's mother, then Sergeant Sylvia Cameron, drove her daughter to the police station to talk to a homicide detective. And during the videotaped interview, Vanessa Cameron actually admitted that she knew Johnson was going to be killed. And her motive for soliciting his slaying, which was argued by prosecutors, was jealousy over his new girlfriend and a $750,000 life insurance policy.
Just right off the bat, it's really astounding to hear that, because this is someone who has family members involved with the police force, just admitting that she was basically part, or at least knew about, a murder crime that was going to take place.
Yeah, it is something that was back when this was tried before, was, a pretty eye-opening thing, and it actually, will be again. And you mentioned other relatives. In addition to Vanessa Cameron, these other relatives were involved in the case. Her sister, Susan Marie Sutton, actually pleaded guilty to murder and agreed to testify against her co-defendants in exchange for a 25-year sentence. Now, prosecutors alleged Sutton lured Johnson to a house and told him that she had money for him that her sister, Vanessa Cameron, owed him. Now, once there, Lakeisha Brown told police that she hit Johnson in the head with a 2x4 before her cousin, Bernard Brown, who was Sutton's common-law husband and Vanessa Cameron's, I guess you could say, brother-in-law, helped handcuff and tie his legs. So Lakeisha Brown also said when Johnson began begging for his life, she put duct tape over his mouth. Now, Lakeisha Brown also told police she and her cousin put Johnson in the trunk of his own car and drove him to Seguin, where Bernard Brown shot Johnson several times, killing him. So Lakeisha Brown also took a plea for 25 years in prison in exchange for her testimony. And in October of 2013, Bernard Brown's attorneys successfully argued he was framed and he was acquitted of murder by a jury, even though his common-law wife, Susan Sutton, and his cousin, Lakeisha Brown, testified against him and told the panel of jurors that he was the trigger man. So lots and lots of twists and turns in this case, Chance, that is actually new to me, because as you mentioned at the beginning of the podcast, this is a 9-year-old case.
Yeah, this is something I say from time to time here on the podcast, but I truly mean it right now. We could stop here, and this is still very interesting, but there's more. The retrial, it's based on a technicality. Tell me about that.
Yes, Vanessa Cameron's conviction was overturned because attorneys for Cameron argued that her relatives weren't allowed in the crowded courtroom during jury selection, thus violating her constitutional right to a public trial. So during jury selection, the 379th State District courtroom was packed. So much so that Judge Ron Rangel ordered that all of the doors be opened to his court, including the ones that led to his back offices and the two sets of double doors that are at the entrance of the courtroom. So in its motion, the state argued that while the pool of potential jurors took up all 65 seats inside Judge Rangel's courtroom, accommodations could still have been made to seat other spectators had the defense actually made the choice to bring those spectators in. So at the time, Judge Rangel told the defense that, yes, it was a public trial and an open trial, responding, of course, to the defense attorney objecting that Vanessa Cameron's family was not present. Rangel said certainly people have an opportunity to observe. He just didn't know where else they were going to put them. So the state wrote in its motion that trial judges aren't ushers and shouldn't have the responsibility of, quote, rounding up spectators for trial. So Cameron ended up going to trial and was convicted and ended up being sentenced to 70 years. But she appealed on the jury selection technicality, and the Fourth Court of Appeals ruled that Judge Rangel hadn't done enough to make space available to the family. And the Court of Criminal Appeals agreed. So this actually was just a really, really small detail in process, really, the way it's been explained to me by courthouse observers, that they were actually able to go and argue this. And this actually, Chance, had been argued a couple of times. So, this is a 9-year-old case. This appeal process has just been going on and on and on. But finally, there was a decision that was made by this panel of higher judges, and there is going to be another trial.
Liz, I'm interested in your thoughts on this as much as you're able and feel comfortable to give. Obviously, I'm not a lawyer. You're not a lawyer. You're a trial reporter, courts and crime. Here with me every week on the docket. So you have a background in this. Just as someone who could offer an opinion, this seems very trivial to me, and I think that to a lot of people, this would leave a very bad taste in their mouth. So much so that it would give them a bad impression of just the entire system. I understand everyone has rights, and it's important to make sure those rights are upheld, especially when you go back and say that something was not as it should have been, and maybe we need to have a retrial. But specifically, to me, this does seem rather trivial. What are your thoughts on that?
It's really interesting because I have sat in on a few jury selections, and basically I was actually shocked as to how packed they usually are. People get called for jury duty, and they playfully call it a cattle call. It's like, oh my God, I have jury duty. Go in and be prepared to wait all day. People take books and all this stuff. So, but once your number is called and you actually have been chosen to be on a panel, you end up going. In this case, there were 65 seats in Judge Rangel's courtroom. So you can just imagine a line of 65 potential jurors standing in front of a courtroom. waiting to be let inside. So you've got bailiffs outside, you've got bailiffs inside, and also inside the courtroom, you've got the judge who's sitting at the bench, who is actually looking at the court file, usually going through what's been going on. And by the time they get ready to choose a jury, they've had all of these pretrial hearings, and they talk about, sometimes strategy about, okay, I'm going to do this. And when I do this, prosecutors, talking to the judge, and then the defense says, well, if you guys do that, we're going to do this, blah, blah, blah. But the whole time that courtroom gets packed. You have all of these jurors that come in. You've got if the defendant has two defense attorneys or three, sometimes you'll have those folks there. Sometimes you'll have experts that the defense brings in too. I mean, I've actually seen some cases where they have jury experts who come in and they all it's all about what kind of questions they're going to be asking these potential jurors. Then you've got prosecutors. You've got in this particular case, there's actually three brand new prosecutors to this case, I believe, who are going to be arguing in the new trial. So you've got the defense attorneys, you've got the prosecutors, you might have an expert in there. You have 65 jurors. You have, members of the media in there who are going to want to observe a high profile case, which this obviously was, because you're talking about a daughter of a police officer at the time. And then you have the option to have your family there. And, one can assume, because it's a public courtroom, anybody else who wants to watch this public trial. So when courthouse observers tell me that jury selection was packed, I believe it, because there's, it is a public courtroom, and people have the right, that constitutional right, to have that. But I guess really the question is, what do you do when you have such that amount of people in there? And in this particular case, Judge Rangel again ordered that all of the doors be open to his court, even those leading into the hallway as you go to the entrance. So in that particular case, you almost have to imagine, my gosh, the courtroom actually extended outward into the hallway. And then it extended outward into the back office's hallway. So, I'm just gonna, as you mentioned, neither of us are lawyers or anything. I'm just gonna say, gosh, that was a pretty good argument that someone made to make this decision, and then to have, this retrial occur.
Yeah, it sounds like as much accommodation was made, but we've made our points. We'll move on. This is a retrial now. So what happens next?
Well, we've been actually in hearings this week in the 226 State District Court. This case is going to be tried there with newly elected Judge Velia Meza. So right now, defense attorneys John Hunter and Gerald Goldstein are going through pretrial hearings and discussing, how they're going to, do things in court with prosecutors Carl Alexander, Jay Brandon, and Anna Ochoa Nelson. And some of what we saw this week was they were arguing what evidence, could, probably will or won't be used in the upcoming trial. And that's going to continue on, likely until Monday, March 11th, when jury selection in the retrial of Vanessa Cameron will take place. But this time, that jury is going to be selected in the 399th State District Court, which, Chance, is the largest courtroom in the Cadena-Reeves Justice Center. So once the panel is selected, testimony will begin. And again, the trial will be heard in Judge Meza's courtroom, the 226th State District Court. So it's unclear at this time how long the trial will go on. But I expect we will see her co-defendants back in court, likely testifying. So stay tuned, Chance, because we will definitely be talking about this case again.
And thank you to San Antonio Express News courts and crime reporter Elizabeth Zavala for joining me once again for today's episode of The Docket, our weekly interview program covering law and crime in San Antonio from expressnews.com. Brought to you today by the law offices of Pat Maloney. For the San Antonio Express News, I'm Chance Dorland.